Thanks very much. Thanks, Elaine. Thanks, Elaine, and thanks, Chip. Thanks, Matt, for being here today and for participating in this discussion. I don't have any inside information as to what the U.S. negotiating strategy is in terms of the NAFTA overall, or with regard to Chapter 19 in particular. For me, I come at this as someone who is an attorney who is practicing in the area of AD/CVD law, and who has had experience in dealing with Chapter 19 panels and with appeals under U.S. law in the U.S. courts as well. And I think as I reflect on that experience and look at the experience that my clients have had even before I've been involved with it, I think one of the things that comes out is that Chapter 19 sounds good in theory, but in practice has really not worked out the way that people thought that it would. And some of that is due to issues of design that perhaps could be improved, but there are other things that are just sort of fundamental about the concept of Chapter 19 as a whole. And I think it's important to remember, and I think both Chip and Elaine have talked about this, that unlike Chapter 20 dispute settlement in NAFTA, where the issue is that a party in a Chapter 20 case, one party to the NAFTA asserts or alleges that another party to the NAFTA has not complied with its substantive obligations under the agreement. And there's a dispute over whether a party is complying with the obligations that it undertook in the agreement. There's binding dispute settlement, and then if a violation has occurred, the violation is either remedied through compliance or through some other rebalancing of concessions. With Chapter 19, there are no substantive obligations with regard to the anti-dumping and countervailing duty laws of each party in the agreement itself. And so Chapter 19 dispute settlement is not about a party's obligations under the agreement. It's rather about whether a party's administrative agencies have complied with its own domestic law. And one of the questions, if you just sort of think it's really extraordinary to have it binding international dispute settlement about, let's say, whether the Environmental Protection Agency properly applied the Clean Air Act. It would be extraordinary to think that we would not have an appeal from the Environmental Protection Agency to the Court of Appeals for the DC Circuit, but instead we'd have a binational panel because, after all, air moves across borders, and clean air issues have an international component to them. And so why shouldn't we have binding dispute settlement over domestic agencies' compliance with domestic laws across the board? And I think one of the problems that comes up is, and I guess I would say that there are several layers of this. The first is, who are the panelists? Anti-dumping and countervailing duty law, for those who practice it, know that it's extremely technical. There are a lot of fairly complex issues. It's a very unique area of law. I always tell people, when I meet people and they say, oh, you're a lawyer. And I say, well, don't ask me to write your will. I don't know anything about that. I don't do that. There are a lot of things this is a very particular specialized area of law. I've practiced in it for a long time. I think I know something about it. But there are lots of other areas of law that I don't know anything about. And if I were dumped into having to make a decision about whether the Environmental Protection Agency complied with the Clean Air Act, I would make rookie mistakes because I don't know anything about that. And I think what happens with panelists is either you get people who are not AD/CVD practitioners, in which case they really don't know the law all that well. They can learn, of course, but they come into it as sort of general practitioners who don't know the law as well. Or they are people who actually do practice in the field, but they have ongoing practices. And so they have developed thoughts about the specific issues that may come up in a case, and you may not know at the outset of the case what issues are going to come up during it, and so it becomes very difficult for, I think, panelists who are practicing in the area to also serve on NAFTA panels because of the issue of ensuring that you're avoiding conflicts. And so I think it's been difficult from the beginning, I think, to sort of find panelists who can really make decisions based on domestic law in an area that where either they're, number one, ongoing practitioners representing clients, or two, not practitioners at all. I think that there's another level to it as well, which I think I don't think was thought about very much, and is perhaps a bit may sound a bit theoretical, but I have to say from my own experience, it's something that I've really seen, that at least in the U.S. system, it's an important part of the U.S. constitutional system to have separation of powers. And for us, it's the legislature that establishes a framework. We have anti-dumping and countervailing duty laws to deal with particular situations. Those laws are political. They are balancing the interests of producers and consumers at a particular point in time, and always subject to change. The administration of those laws is given to executive agencies, whether in the U.S. it could be the Department of Commerce or the International Trade Commission, some aspects of it with Customs and Border Protection. And then you have judicial review, which comes in to make sure that the intent of Congress is in fact being implemented properly by the agencies, and that due process is being given to all the parties who are concerned. And in that, each group has a different role, and yet there's an ongoing process and dialogue. If you go to the Court of International Trade in New York, which normally hears all appeals of AD/CVD matters, or if you go to the Court of Appeals for the Federal Circuit, which hears the appeals from the Court of International Trade, these are courts that deal with these agencies regularly, that deal with these laws regularly, and they make decisions. When they make a decision in one case, they're thinking about how that decision affects what the agency is going to do in the next case, and the case after that, and the appeals that are going to come after that. And one of the things that I've seen, as Elaine said, without getting too much into any one particular case, I do work with the U.S. Lumber Coalition, which, before I started working with them in 1993, had a NAFTA panel case that was decided 3-2 on national lines, in which a countervailing duty order was revoked based on the binational panel decision on two grounds. Both of those grounds in 1993 were then the U.S. law was changed in 1994, and Congress said we are clarifying this because binational panels have gotten it wrong. This is what the law has always been, and you had a 3-2 decision that was on national lines, affirmed by an extraordinary challenge committee, voting 2-1 on national lines. And as you can imagine, my clients don't have a happy memory of participating in that process. And then in the last round of lumber cases in the early 2000s, I did participate in the three panels that Elaine mentioned in each of those proceedings. And I have to say, as somebody who has litigated in these cases, each of those three panels did things. And I'm even not talking about substantive decisions that I might agree with or disagree with, but each of those panels did things that no U.S. court would ever do in terms of how they treated the agencies, how the process, how they treated their own decisions, and without relitigating any of that, you can say that's sour grapes. I've litigated cases in the U.S. courts and lost in the U.S. courts, and I have to say, especially at the Federal Circuit. When I've lost a case at the Federal Circuit, I walk away. Every time I've walked away saying, I'm disappointed, I think we were right, but I understand the arguments on the other side, I understand the court's rationale, and I can't say that I was denied my fair day in court. I have never felt that with a binational panel. In fact, I've always felt the opposite. And so Again, you can say that that's just a perception, but it is in fact the perception of a lot of industries who have dealt with Chapter 19 in the past. And it also, from the U.S. perspective, I think raises constitutional questions. You have people who are appointed outside the U.S. constitutional system, appointed in part by foreign governments, who once appointed cannot be removed even for cause without the consent of that other government. And yet they have the power under U.S. law to tell U.S. cabinet officials what to do, what duty rates to set or not set. As the Supreme Court recently said, if the president cannot supervise the people whom he appoints and who are confirmed by the Senate, he cannot if he doesn't have the power to hire and fire, then he does not have the power to take care that the laws be faithfully executed, which is what the Constitution requires that the president do. And so the Supreme Court has struck down a number of provisions in law over the years that where you are putting unreviewable power over U.S. executive branch actions in someone that's not accountable to anybody under the U.S. Constitution. Let me just conclude by saying, if in fact NAFTA is problematic, Chapter 19 is problematic, why was it agreed to in the first place? And I think we've already heard that part of the problem was it's very important to have binding dispute settlement if you're entering into a free trade agreement, and I understand the concern that Canada had in 1987 when the first free trade agreement with the U.S. was being negotiated. I think it's a very real concern, and that it is something that needs to be respected from the U.S. side. I also think that having refunds of improperly imposed duties is also important, and the U.S. courts do provide that. And I guess the question is, why is it necessary to go outside the U.S. court system and create a separate set of international dispute settlement for AD/CVD matters? I think in 1987 it was much more important than it is today, because we do have the WTO today. In 1987, not only was there no binding dispute settlement under the GATT, but there was no universally agreed definition of subsidy under the Tokyo Route Subsidies Code. But now in the WTO since 1994, we do have those things. And we do have binding dispute settlement, and that has largely replaced, as has been said, has largely replaced dispute settlement under the NAFTA for other matters. It seems to me that Chapter 19 is not nearly as important today for those who believe it is important to have prompt binding decisions that involve refunds of AD/CVD duties, and that provide for binding international dispute settlement for the international obligations that the United States and other NAFTA parties have entered into. We have those things already in the U.S. courts and in the WTO. So from my perspective as someone who has litigated in this area and has represented clients in this area, it is Chapter 19, I think, is a flawed system that addressed what was in 1987 a very real problem that is in fact really not a problem anymore. And today the flaws outweigh the benefits that it can provide, since those benefits have largely now been provided through other means. So with that, I'll turn it over to Matt.
Thanks, David. That was very helpful, thank you. You touched on several things I wanted to touch on and save me from having to do that. As has already been mentioned, I come at this from more than one point of view. First of all, I chaired one of these panels many years ago. Subsequent to that, I was not only the Deputy Assistant USTR for North America, but I also chaired the U.S. Government's Interagency Softwood Lumber Committee and U.S. delegation to U.S. Canada's Softwood Lumber Talks, and lumber, of course, and Chapter 19 are closely connected because lumber has been particularly affected by Chapter 19. I agree with a lot of most of everything that's been said so far. I would say, though, that if the United States doesn't get Chapter 19 removed from NAFTA, the sky will not fall, and I'm going to explain why I think it's not as problematic as some people are worried that it is. But I'll start by doing this. I'm no stranger to sticking my neck out, and I'll do this right now. I've done a careful analysis of this, and my view is that it's extremely unlikely that the United States will get Chapter 19 removed from NAFTA in the current NAFTA renegotiation. That's my neck stuck all the way out. But it's not 100% certain, but I would say it's extremely unlikely. For one thing, it's so important to Canada, I can tell you, that I don't know that all of the United States has very limited leverage in this negotiation, something I won't digress to because I've discussed this before and on WITA panels, but we have very limited leverage in this negotiation, and all of the leverage we have might not be enough to get even that one concession if we put it all behind that one, our request for that one concession. We have less leverage than you think, and this is more important to Canada than you think. Canadians believe this is more important, the Canadian government believes this is more important to Canada than you might think. Whether it actually has that big an effect on Canada is another question. Second of all, a couple of factors that have happened recently. What I just told you, I would have told you over the summer. I've learned two things since the summer. One is that Ambassador Lighthizer is very, very highly prioritizing the removal of Chapter 19, very highly. That's not inside information, but it is my analysis of publicly available data points, and I don't have time to go into them, but looking at them closely, it's clear to me he's got extraordinarily high prioritization on that, and because he's an anti-dumping duty and countervailing duty lawyer, I'm not surprised. But another thing, of course, that mitigates in the direction of a tiny chance we might actually pull it off, but mitigating the opposite direction, as has already been mentioned, is this is softwood lumber and aircraft. Right now, we're trying to renegotiate a softwood lumber agreement. If the softwood lumber agreement renegotiation is unsuccessful, then softwood lumber will remain in the anti-dumping duty and countervailing duty regimes indefinitely. And we have we're most of the way through investigations, anti-dumping and countervailing duty investigations on Canadian lumber. Bottom line is, if there's no softwood lumber agreement, that means there is anti-dumping, countervailing duties almost certainly, and those will be appealed to Chapter 19 panels. So if there is an agreement for several years, lumber is taken out of the anti-dumping, countervailing duty regime, and Canada will care a little bit less about Chapter 19. If the softwood lumber agreement negotiations fail, then Canada will care a lot more. So that's another factor in the mix. And the last thing is this aircraft decision, which is staggering. You need to take a breath on this. Bombardier just stepped up in regional aircraft manufacturer in Canada, started manufacturing planes that are much larger than it used to, that now directly compete with Boeing's smallest planes. And as a consequence, now Bombardier planes, which are subsidized by the Canadian government, are threatening to, or it's alleged, and it's been found at least preliminarily, that they're threatening to cause injury to the U.S. industry. And so a 220% deposit rate has been imposed on Bombardier, the large aircraft coming into the United States. It's only a deposit rate. We don't have the final determination yet. But that rate would shut down Bombardier exports of those new planes to U.S. carriers. It would literally triple the price. Delta already made the first order of $5.6 billion, and several other U.S. carriers are looking at these planes. We're looking at what could be anywhere $5 to $15 billion of Canadian exports to the United States in good years on these planes if these duties didn't exist. And we're looking at duty rates that would shut down these exports completely. Now, NAFTA, $1.2 trillion of trade, but that's Canada and Mexico combined. That's goods and services combined. That's imports and export combined. If you look at Canada, goods exports to the United States, those numbers alone are 2 to 5% of all of Canada's goods exports to the United States. That is a staggering impact for a single countervailing duty order, shutting all that trade down. That's quantitative analysis. It's not a matter of opinion. It's not subject to politics. It's got nothing to do with the administration or with the NAFTA renegotiation. It is what it is. The subsidy was what it was, and the decision is what it is. But the bottom line is that Canada looks at Chapter 19 as its last possible straw to grasp at to maybe save itself from this very significant countervailing duty rate, which might turn into a countervailing duty order. So in the final determination, which hasn't come down yet, it'll come down in December. So this is really, really important to Canada. Consequently, I really don't know that it's going to be likely that we're going to be able to have enough leverage at the table to get rid of Chapter 19. Now, David made some very, very good points, and that's the second thing of the two things I wanted to talk about, is how do we improve Chapter 19 if we can't eliminate it? As former chair of a panel, I have a lot to say in that subject. David's comments were the first I've heard publicly, and they were very astute and correct. I liked the analogy, the biggest problem, and I never hear this spoken about, is what they pay panelists. And I'm not talking about that because I was a panelist. I mean, it has no impact on me. It was a long, long time ago, and I'm sure I won't do that again. But you have to understand, the United States has an anti-dumping duty and countervailing duty bar, which has phenomenal expertise in this absolutely staggeringly complex area of law. Their lawyers spend 40 years doing nothing but anti-dumping duty and countervailing duty litigation, and when they're done with their careers, they know 1/20th of the field. Canada has a few lawyers in that category also. You can't get those people to do a panel for what we pay. The people we want in those panels are the Lighthisers, the partners at top firms, whether they're big firms or boutiques is unimportant, who do just this stuff, who are deep experts, 20, 30 plus years doing it. That's the people we want. Okay, the regular hourly rates that their firms charge for their time, $800 to $1,200 an hour. All right, those hourly rates support whole law firms. Some of the boutique firms maybe have smaller rates because they have lesser overhead. But they support whole law firms. They don't just support the partners' salaries. Maybe $600 to $800 for firms with lesser overhead. But the point is that you can't get these people when you're paying $80 an hour, which is what they pay. And so the United States gives up the opportunity to have the A team in there. And to some degree, we give up the opportunity to have the B team. When I chaired a panel, I was by far the most expert person on my panel, which is why I was elected to the chair of the panel, and I was still B team. I've not spent a career doing only anti-dumping and countervailing duty law. I've done a lot of different things. I've done customs law, everything across the board. That's some of it, but I wasn't A team on this. And I have far more background than the rest of my panel. Look at it this way. Imagine somebody came up with a mathematical problem that for 50 years all the great scholars in mathematics couldn't resolve, right? And they decided to form a US-Canada binational panel to resolve this mathematical formula. And all the top scholars at MIT and Harvard and Germany, wherever, they all come and they actually, one team figures out what they think is a solution, they got a proof, the other team figures out what they think is a solution, they have a proof, and the proof is like rows and rows of mathematical formulas, epsilon, the cube root of pi, and da-da-da-da-da, right? And then there's the panel, right? It's got 2 Americans, 3 Canadians, they're all high school math teachers. And these guys come along and they say, and they're arguing which of these proofs is the right proof. And these high school math teachers sitting there going, yeah, okay. And maybe the chair, maybe he has some college, maybe he has an undergraduate degree in math. This is what happens on these panels. It's not really a problem of faith. I have found panelists are all operating in good faith. They're all trying to make the right decision. They're not breaking the rules. They're not trying to be biased or patriotic. But they're standing in the shoes of the U.S. Court of International Trade and the U.S. Court of Appeals of Federal Circuit that do a lot of these cases and have a lot more expertise than they do. And they're evaluating decisions, investigations, analyses, and decisions by the ITC and ITA, which have huge bodies of knowledge in this area. They have teams and teams of economists and lawyers and experts who do nothing but anti-dumping countervailing their whole careers. They have breadth and depth. You know how intimidating it is for a panelist who barely even grasps what's going on to tell them that they're wrong? Now, a U.S. federal judge, not the same. See, telling a U.S. government agency that it's wrong, that's what a federal judge does for a living. U.S. federal judges only do 3 things: federal criminal cases, large civil interstate cases, and telling U.S. federal government agencies when they're doing something that's not consistent with the statute that authorized them to act. Okay, that's what judges do. So you have federal judges who have more expertise in the field and who are more mentally prepared to tell the ITC and ITA that they're wrong. Then you got these panelists who are doing a one-shot deal. They don't even normally sit as judges. They don't have as much expertise. And that's the struggle. And there's no question in my mind, instead of paying $80 an hour, we should be paying $800 an hour. And we should be getting the top people. And if we got the top people from Canada and the United States and from Mexico and the United States, we would have much more consistent decisions, and we would be much less anxious about this process. One last thing I'll say on that subject is, for example, with Chapter 11 panels, when they go to the London Court of Arbitration, etc., those arbitrators get those rates. Those are their regular rates at their law firms, whatever, and they get those rates. International arbitrators do get those rates in most other arbitration fora. So there's a lot that can be done to improve the quality of the panels if we can't get rid of the panels. I think there was many other things I wanted to say, but I think I don't want to overstate my time, so why don't we go to questions now?